I'm Manoj Kumar Chaudhary, Advocate, Supreme Court of India, and a National Convener of Nani Palkiwala National Law Club. Welcome you all on behalf of Nani Palkiwala National Law Club in this webinar of Tips and Tricks of AOR Exam 2025. Today we have a Jayprakash Somani, Advocate, Supreme Court of India, and Founder Director of Nani Palkiwala National Law Club, as a host of this program, who has written more than 60 plus books on a different case laws of Supreme Court of India. Over to you, sir.
Thank you. Thank you, Manoj. Friends, let me tell you about the AOR examination. This year, in 2025, AOR examination is going to held on 16th, 17th, 20th, and 21st June 2025. Okay. And it carries 4 subjects. So first subject is practice and procedure of Supreme Court. Second is drafting. Third is advocacy and professional ethics. In this subject, Dr. Mithilesh Jha has taken 89 marks, good marks, very good, fantastic marks. His introduction, later on, Manoj will give you the introduction after this small speech. Then fourth subject is leading cases. With the grace of Lord Krishna, I got the opportunity to publish more than 60 books on Supreme Court case laws. In that, 3 books on AOR examinations. So leading case, drafting, everything will cover. And just you type the Jayprakash Somani books on Amazon or Flipkart, you will get my books also there. And you will find the 4 videos on 64 case laws on YouTube channel. And recently in syllabus, 22 new cases they have added. So we will add that cases later on in our books. Always will prepare one video also on these 22 case laws. Friends, this examination is a very challenging examination because you have to study hard. Passing percentage is 60%. Minimum passing for one subject is 50. But if you get 40 marks in one subject and aggregate, if you get 60%, then you can give that particular subject in next subsequent examination. So that is a provision. But if you are not getting 60% marks, that time you have to give all the papers again. And in this examination, you can give only 5 times you can give this examination. And if you fail in first attempt in all subjects, then you cannot give this examination again. But for that purpose, you have to convince the examination body. And if examination body is ready to give you the chance more, then they can give you chance more. So step up fantastic there. Practice and procedure is mainly related to the practice and procedure. Supreme Court Rules 2013 and Supreme Court Rules Practice and Procedure, that is 2017. These 2 books are very important for that. And on that books, on that information, you can write that paper. All paper are scoring also, and all paper are creating also. So that is depend upon your skill, how you write like that. And I'm an arguing counsel. Even though I have written and published 3 books on AOR examination, but I have not cleared that examination. I have not given that examination, AOR examination, because I come in Supreme Court at the age of 55. And at that age, I don't want to file any case like that. So just I'm interested in argument. And with the grace of Lord Krishna, in my law firm, more than 13 advocates are there. And out of that, 6 are AOR also. So we have the best setup for my arguments. So, but a person who want to establish the practice in Supreme Court, to give examination and to become AOR is very essential. to establish the practice. Otherwise, as a lawyer, you can argue in Supreme Court, no doubt, because that right you are getting that right in Advocate Act. As for Advocate Act, you can argue in any court, including Supreme Court of India, including all tribunals, including all the trial court, all the appellate court, everywhere. It is not necessary if you are the member of Delhi Bar Council or Maharashtra Bar Council. If you are a member, and then you cannot practice beyond the Maharashtra. No, when you are the advocate, you can argue in any court in India, including Supreme Court also. So for argument, no restriction is there, but for filing, there is restriction. You should be AOR. And for getting AOR examination, after getting AOR examination, you should stay within the radius of 16 kilometers from the Supreme Court. So that is the main system. And you have to take one register, one clerk, everything. They will give you, after clearing examination, they will give you the training also. And you can work very nicely as AOR. And the second paper is a drafting, all drafts related here. So in this paper, you will get more 30 marks, 30 minutes more for reading the question paper also. All other papers, you get only 3 hours. But in this particular drafting paper, you 3.5 hours. Half hour is only for reserved for reading the newspaper. So third is advocacy and professional ethics. Advocacy and professional ethics include the professional ethics, bar council rules, regulations, history of our codes, everything. Syllabus is given. If you download this circular from Supreme Court website, you will get all total syllabus. Then fourth paper is leading cases. This is the most challenging cases paper. You will get a book with you. You cannot carry that book, but you will get the head note book. Registry will give the head note book at the time of paper. In that head note book, you will get all these 86 cases. Okay, and by referring that book, you can write that paper, but it is very hard. Unless and until you go through each and every judgment, okay, you cannot write that paper. So challenging, very, very challenging, because earlier, till last year, only 64 cases was there. Now 22 cases they have added. So this is the things. So Manoj, now introduce Dr. Mithilesh Jha.
I welcome our guest, Dr. Mithilesh Jha, AOR Supreme Court of India, ex-judge in this Nani Palkiwala National Law Club for this webinar. He is formerly a higher judicial service officer. He cleared the judicial services in the first attempt. Then again, he has cleared the AOR exemption again in the first attempt with, as sir told, 89 marks in a paper 3. While he was in the age of 60, along with enjoying his grandchildren, he has cleared his AOR exams. This is a great motivation to all the AOR aspirants. Then
thank you so much.
Not a bar for anything, and you can achieve if you have a will. Over to you, sir.
Yes. Thank you.
Thank you.
Thank you.
Thank you.
Thank you. I know that. Mithilesh, Dr. Mithilesh, this program is of AOR. I should not speak beyond the AOR examination syllabus and everything. But just I want to listen from you about your judicial journey in short. Judicially in journey short, because you retired as a district judge. Okay, so because the audience will agree with me, they also want to listen your journey also. So just within 4 to 5 minutes, your journey up.
I have joined the judicial service in the year 2002 in the state of Uttarakhand at the age of 38 years. There I served, since I have joined judicial service in PCS J cadre. So I have served in the post of civil judge, thereafter civil judge senior division, CJM, ACJM, additional district judges, and lastly I was judge in the family court. I was enjoying good because the state of Uttarakhand is good. But I had some difficulty. I was facing some climatic problems, which was causing some allergens to me. So that caused me to seek voluntary discharge from the service. And frankly, even during my service, probably I had some intention to become an AOR because I had started my career as a lawyer at Delhi. I have before joining judicial service, I have practiced before most of the courts at Delhi. So that was also giving me some sense of changing and taking legal profession again. So with that intent, I sought voluntary retirement, but Corona was in between for 3 years, and so even I suffered from Corona in first phase of first wave. I suffered, and that caused me a serious illness to me. Especially, I got sugar, blood pressures, and other. Especially after Corona, I have got all these problems. But I had to maintain myself. Then I had to also focus that I have to become a AOR because personally I feel that Supreme Court practice gives opening to three type of people. Either you should have been traditionally practicing either at High Court or at Supreme Court, so that you are a known advocate, you are a known jurist, like our Honorable Jayprakash Somani Sahab, or anybody who has 30, 40 years exposure in the sole domain of legal profession. So probably by virtue of their exposure, they become a exponent in that faculty, and people know them by their exposure. But everybody cannot have the same opportunity. So personally, I have understanding that Supreme Court needs to another type of people. Like either he should be a designated senior or he should be AOR, so that he is in mainstream. So since I was in third category, I had not much exposure like Upper Honorable Jayprakash Somani sir. So I thought to crack the examination of AOR at the when I was 59 years of age. After having eligibility and have undergone training, etc. Again, because was I was to discharge the social responsibility like marriage of my son, marriage of my daughter just before examination, and
Oh,
just before examination exactly, sir.
even though you clear this examination in first attempt, that is credible.
Even during the examination, my one of the loving grandson, he was in ICU. So what happened? Last paper I wrote, and hurriedly I from the examination hall, I had gone to catch the train. So
Oh,
even when I had gone to appear the examination, I was with bag because I had to appear the examination, and I had to go to attend my grandson. So that was a peculiar difficulty. But still, I prepared well, and I thought that
Dr. Mithilesh, can you tell
yes.
me from which month you have started for preparation of this examination? How many months you required, and what is average your timetable daily?
Basically, I was engaged in legal profession also, so I had a focused idea that I should concentrate at least 4 hours per day. Even to have 4 hours, it is a biggest challenge for the practicing advocate because normally we are unable to, especially practicing advocates are unable to get that 4 hours. So for that very reason, I had a plan that at least 2 to 3 hours I will complete my task, portion of my work in the morning before I am out of the bed. So before I am out of my bedroom, I thought I had a plan that I can complete at least 2 to 3 hours. And somewhere again, before going to bed, I shall still because living in the joint family, and at the age when your grandsons and other people are school going, college going, and you being a grandfather, it
Hmm.
becomes little difficult. But that was a process I was adopting. I was trying to concentrate at least 4 hours per day.
Mhm.
And I had started my preparation seriously after March, sir.
Okay, okay.
Seriously,
Yes,
after
yes,
March,
sir.
sir.
Yes, yes. I
Sure,
will
sure.
take separate program of you on professional ethics, detailed study and detailed paper practice. But
Sir,
today
please,
this
sir.
is just a motivational speech. So
Sir,
I,
sir.
all the audience will like to listen how you prepare each and every subject. So tell me the first subject, our procedure and
Sir,
practice and procedure of Supreme Court. How you
uh,
prepared that?
for practice and procedure, personally, I feel that, and I have prepared, I have gone through the Supreme Court rules. I have gone through the practice and procedures handbooks, which is available 2017, which is available either in photocopy or somewhere in other shape, and other books also on the same issue. Then I have gone Contempt of Court Act, and besides this contempt, I have gone through the Constitution relevant portion. And beside that, basically all these four papers are interlinked, because once you are preparing for one paper, you are preparing for other papers also, and it cannot be read in isolation. Like
Very
in
true.
case some, because in case somebody is preparing for leading cases, so if somebody is good at leading cases, those leading cases has to be cited at different page of examination, even maybe in the first paper, maybe in the second paper. And somebody is preparing for leading cases, so he is aware that how to deal with the case, how to draft, what is the question, and how those questions have been decided by the courts, honorable court, in different page in the past. So
Mm.
every papers is interlinked. However, for the first paper, I mainly concentrated on this. Then for the second paper,
No, no, no.
uh,
I will ask you about second paper later.
sir.
Dr. Mithilesh, you tell us how you manage your time at the time of writing that paper. 3 hours. How you manage for this practice and procedure?
Basically, before the examination, I used to take at least 10 days.
Hmm.
I used to take myself into the real examination form in a simulated example. So I used to take one of the previous year's question paper, and used to try that whether I am unable able to complete those paper or not.
Very good. And
So,
then that means daily writing
writing,
practice.
writing practice daily, and also personally, I have a token of suggestion for every aspirants that they should read for an hour, then write for at least 2 hours,
Oh,
and
this is very good.
write for 2 hours, and think for 3 hours. So I devise a technique 1:2:3, because see, once we read, we find that we have read lot of things, we know everything, but once we start writing, we somewhere find glitches that we are not able to write, and sometimes we may not recall the exact visions. So for that very
Issue is
reason,
there. Yeah.
1:2:3, because sometimes even during the leisure, even somebody is working in the legal field, or practicing law as a lawyer, even while traveling in metro, while traveling in car, we can recapitulate the thing, that what are the topic I have covered, and exactly what I have understood, what was the take away for me. And even we may put a question in ourselves, that in case I have been confronted with this, like in case somebody is confronted with a curate petition, then he must be aware that how the history, what is the history of curate petition, what will be the tentative origin, and what are the good steps in this direction. So all these, so until somebody recapitulate, keep on reminding themselves that what are the core and what is the core segment in that, so probably it becomes difficult. So personally, I suggest every aspirant that they should read little, write more, and think most, so that they can make sure that they are aware that they are competing and completing the task. Sir, I think your video is off, sir. Can you hear me, sir? Sir.
But no issue. No issue.
Sir.
Proceed, sir.
Sir. Sir.
We are on first subject.
Sir.
Practice and procedure.
Sir. So for first subject, basically, preliminarily, I have concentrated on Supreme Court rules because that is basic and core. And the Supreme Court rule is also supported by practice and procedure. We have guidelines on that, 2017 publication. Now, basically, even in Supreme Court rules, all the chapters needs extensive preparation. But it was convenient for me because I thought that it is something in pattern of CPC. And we had studied CPC, so in same pattern, and since CPC is a very bulky book, in comparison to CPC, Supreme Court rule has very scanty provisions. But for the purpose of preparation, I adopted the same mode. And when I was taking the examination, I was remembering most of the provision, starting from order 1 to last. So I suggest every candidate to have, while practicing at Supreme Court, whether somebody becomes an AOR or not, but even somebody doesn't become an AOR, still practicing or studying or remembering the orders etc of Supreme Court rules or the guidelines provided in the practice and procedures or the provisions mentioned in the Contempt of Court Act or any of the allied books or provisions of the constitutional provisions, especially of jurisdiction of the Supreme Court, especially of the powers of the Supreme Court at different occasions. So those are very handy, whether somebody becomes an advocate on record or not. Even somebody doesn't become, still those are very useful for the advocates throughout to become a good advocate. So in the same way, even I had in my mind that mostly if everything goes in a right way, I shall clear the examination. But even second idea I had that even if I do not clear the examination, at least I am getting something, some bigger changes, some bigger inputs, some bigger statutory provisions I am remembering and knowing. So that will make me some better lawyer. So with that perspective, also to have knowledge, I was concentrating on that. So.
Very good, very good. Dr. Mithilesh, can you elaborate the drafting paper properly? How one should prepare the drafting paper, and then how should that writing? Because writing speed is very too much required in that paper. Your legible handwriting should be there like that. So just elaborate on that paper.
Sir, truly, drafting paper is little havoc-full for all the aspirants. But personally, I have a different ideas. I think drafting paper is one paper with which we all the advocates are acquainted with. Because drafting paper is the paper we learn from the stage class 5. Because once we put up an application to the principal for grant of leave, or some exigency grant of free SIP in the schools or colleges, we start drafting from that point. Even during law education, we have a paper of drafting, pleading and drafting. So this is one paper which take its origin from our childhood. While other papers are different paper and other papers needs a different segment of preparation, but in this particular paper we have started drafting from the beginning. So for me it was not a very causing concern, but also since I had an exposure of almost more than 20 years in the field as a judicial officer or also an advocate, so that was not causing concern. But again, writing and since Supreme Court drafting is little different, so I was concentrating on something basic. First thing, like provisions of Form 28, Form 32, Form
that
33.
Is SLP. Form
Sir.
20 is related to special leave
20,
petition.
Especially petition, and 32, Form 32 relates to writ petition, sir.
Mhm.
Writ petition, Form 33 deals with PIL, and Form 34 deals with the caveat in the Supreme Court. So these are only 4 forms mainly are prescribed. So why you have to concentrate on forms? Because in case you are asked or you are confronted or any experience is confronted with questions from this, then we are bound to follow the exact prescription provided in these forms. However, in other situation, like somebody is writing counter affidavit or somebody is writing for exemption, etc. So, since those are not some strict forms, some forms have been not be provided. So sometimes everybody may attempt in a different way. But remembering these 4 forms, first thing. Secondly, drafting paper is set by the examiner with an intention to assess the examinee with at least 4 angles, like what may be the structure, then what may be the narration, jurisdiction and opening para. Jurisdiction and opening para. So what I suggest to every candidate, that in every drafting paper, whatsoever question comes, whatsoever we're confronted with the situation, at least there are 8 stanza in every drafting part, like opening. So opening in Supreme Court pleading and drafting, we have got at least 6 lines. So those 6 lines, without variation, we should try to remember, and that can be done by repeated writing, because sometimes you might omit one thing, sometimes it might overlap, or sometimes it might get inter exchanged. So to avoid that multiplicity, we should constantly practice that 6 part. Then even the closing para or the exact wording what has to be taken. Like in case somebody is drafting SLP, then like declaration under rule 2 or rule 4, or declaration under rule 3 or rule 5, as the case may be in civil or criminal SLPs, exact words we must pick up, and exact words can be picked up by repeated writing, because exactly we might understand the sense of that declaration, what exactly it may
So
need.
as per your view, writing practice is very much important in
Ve-
drafting
ve-
paper.
Writing paper is drafting paper, sir. Very much important, sir.
Okay. Now for give some focus. Do you want to tell something more on drafting paper?
The drafting paper, what I have a token suggestion, that even if the candidates do not know anything on that line, some questions, like last year questions paper, in first paper, almost 50% questions were asked related to drafting. So what happens, even you may not have some ideas, but still you can attempt. Like you can have just ideas of uh, leave application or pre-SIM application at the school, where we write to the principal, then we write subject, then we write salutation, and then we have a 3 parts of body. First you write that what is your problem, how it originated, and then the third part you write that what is your relief you want, and at last you bottom you write who you are. So like these 8 stanzas. So if this, in case, just remembering that simple application at school stages, and you might not be aware, or sometimes you might not be aware about the exact statute or the power from which you derive to draft. Still, even if you write the sense that you are writing this application, so one portion that you have omitted the provisions and subsection, but at the same time, still you are fetching marks. I am sure that even if you are attempting these way, probably you are getting 50% marks. If you are writing provisions and other thing, you might get 80% or 70%. But even if you are writing just in the without mentioning proper provisions, like somebody is asked that exemption application from filing, from appearance, from surrendering of something. So sometimes you may not know exact provision that this has been mentioned in the Order 22 Rule 7. But even if you write that you are writing the application for exemption from surrendering, so court might get convinced that you are aware, or the examiner might give you sufficient mark on that, or every marks might be very useful for you. So
Okay, okay. A very nice explanation, very script explanation. Now,
thank
give focus on your favorite subject in which you got 89 marks out of 100. That is
sir,
professional ethics and advocacy. How
sir,
you
sir, sir,
prepare that?
sir, thank you, sir. Basically, as an examinee, I prepared all subjects in a very equal manner. And my initial conception, and it remains there, that out of these four paper one and paper three, where you can have a command over that, and you can score like a paper uh, two drafting or leading cases, that might have a variation, because that is not something like mathematical. Drafting, even your draft might be appreciated by examiner, might not be appreciated by examiner. But in case if you write statutory provisions, etc. in paper first and paper three, so probably you are getting marks like mathematics. So even I had the same concept, so that these two papers are very useful. And of course, I prepared all papers equally, but I could not get equal marks. That was peculiarity of this examination, because you are not sure that how and what you are writing. I'll cite an example that there was one question in practice and procedure, that what are the guidelines for filing SLP, sorry, PIL in Supreme Court. Basically, on this issue, I had enough material in my brain, but this was a question of 5 marks. I thought to write two-line description and 3 case law. I thought that that probably might impress the examiner. But that 5 marks question just gave me 2 marks. Answer I got out of my attempt, I got only 2 marks. Where basically, in case I could have written description of Form 33, description of Form 33, what are the obligatory point, or the what are the guidelines propounded by Honorable Apex Court, and there are very sufficient guidelines, especially after Uttarakhand case, sir. There are there was Uttarakhand case in 2003, which is the guidelines of the
Yes,
subject. Sir,
yes,
2000,
yes.
sir. Balwant Singh Chopal, sir.
Correct,
Sir,
correct.
Balwant Singh Chopal versus State of Uttarakhand. So in that, the guidelines have given. So I must have written the guidelines instead of writing judgment. And judgment could have been a larger portion. So it is not that how much you know, but it is very important that exactly what you adduce in writing, and what strike your mind at that moment of time. So for that, to avoid this situation and to avoid this situation successfully, I suggest all the aspirants that before you attempt to write, think at least 30 seconds. Think 30 seconds and have a frame of answer, that you are going, this is a question, because a lot of questions are very critical, and a lot of questions are confusion, which may have a different, like last year in practice and procedure, one question was related to contempt jurisdiction. And in contempt jurisdiction, I have I have attempted, but I haven't got good marks, because probably I have not framed my answer before answering that question. So
I
what
think I think in professional ethics paper there are some case laws also, no? They
Sir,
are
sir,
asking some questions.
sir, I shall come. I shall come on that, sir.
Yes.
Sir, I shall come on that, sir. So, my suggestion is that every candidate, every aspirant must have a thought, must give a very calculated thought for 20 seconds, 30 seconds, and have a frame of answer, that in this way. As far as the paper 3 is concerned, I think it is a very limited topic. In case somebody wish to pass the examination, and especially when you have a feedback from the expert and examiner, likely examiner or members of the board, they give you some clues. Like last year, the questions were most of the questions were out, but but uh, how you are attempting, like somebody is confronted with a question of strike, like last year this was a question. So it this needs this has a case law of 10 case law starting from 1998. You have to travel to 2022. So starting we have so there is chronologically 10 case law. Starting from common causes cases or registered society in 1998, and we have to move to Ishwar Chand Sandelia versus Dehradun Bar Association, because paradigm shift. And in that connected question, there was also a question that whether there is an exception to that. Then definitely we have to have a gross understanding of Hari Sutwa versus Union of India 2002. So my idea is that on every subject, like I have made a note on every subject, like in case if I'm discussing strike, sorry, then I have all 10 case law chronologically starting from 1998. In case, let's suppose that we are discussing something about solicitation of war, or um, there is different situational question, or like some of the questions are open question for this paper. Like what I suggest to all the examinee, that in case somebody prepares the regulation rules and made under section 49 1C of Advocate Act, and rules made by Bar Council on this duties of advocate.
Yes.
Duty of advocate starts from 1 to 56. And now, in case I think every candidate prepares all alone a duty of advocates, because all the questions had its inception and birth from duties, whether may it be related to a strike, may it be related to duty, or sometimes candidates are confronted with several questions like client's mouthpiece, or somebody is forced to accept brief, or advocate can refuse the brief, or advocate can go on a strike, or advocate can accept employment, etc. So every question, every advocate can address press or note. So my token of suggestion is that in case every candidate prepare a duty of advocate starting from 1 to 56, and seriously on that, and deals in different case law. So probably he is through on that point, because all the different questions arising in this particular subject has its inception from that 1 to 56, sir, every topic. And I had made a separate note subject wise, like on a strike, or the press, or the search and seizure, then practice by foreign lawyers, especially duties part. When I have I had gone to examination hall, I was remembering 1 to 56. I was
Oh,
When I had gone to examination hall, I was remembering 1 to 56, and this question was asked. But during examination, while writing, I missed a few, but still I could write 40, 45 duties
mhm.
chronologically, sir. I had written that. So,
That
so
chronological is very important.
chronological is very important. Also, sometimes situational question, like sometimes questions are asked that some murderer comes to the advocate on record, or advocate, and he confessed that he has committed murder. And in question, they put that, are you going to accept his brief, or that murderer deserves. So it is not all alone a question, but it needs a lot of synoptical constitutional provisions, and then we have to go into bigger side, and basically to have a good marks, like like last year in this particular paper 3, there was a question related to duties of AOR, duties and responsibilities of AOR. That was a question of 15 marks. So I have started how the system of AORship has originated, and I am so 1, 2, 2, 3 case law on that, and from that then I have entered into order 4. Then I have narrated, and I got 15 out of 15, sir. Basically,
Okay.
these 89 marks I got out of 90 exactly, because what I have committed a mistake. I have conceived one question was supposed to be of 5 marks. However, it was exactly of 15 marks. Because, sir, that question was in continuation of 5 marks, 5 marks, 5 marks, 5 marks. I was hurriedly written 15 marks question as 5 marks. And my thinking was that for 5 marks, I shall not move more than 2 pages for 5 marks question. But however, for 15 marks question, I had in pre-decided ideas that I shall write at least 4 pages. So I understood that 15 mark question as of 5 marks, and I have attempted only in 1.5 page. However, I had enough material and enough time, but despite that question, I got little lesser marks, sir.
Dr. Mithilesh, now
Sir.
we are on last stage,
Sir,
that
sir.
fourth paper, leading cases.
Sir.
When you appeared this examination, that time these cases was 64, and now
Sir.
these cases are near about
86,
86.
86, sir.
So
86.
how you can guide to the audience about this leading cases paper?
Sir. Basically, for leading papers or leading cases paper, initially I prepared my own note from SCR. And for making my own note, I have divided every topic, every case law in different segment. That what is the controversy, what is the origin of controversy, what is the controversial point, how the court has dealt, and what was the differences of opinion between between the bench, and whether has it been followed or not. And out of these, what are the important allied dates in that particular judgment? This is the way initially I prepared. And in latter phase, I had an idea that I should have a very, very gross understanding of all 64 cases, for 2 reasons. Even if I do not become an advocate on record, still I it will give me enhanced edge to have knowledge of those allied subjects. So I prepared to have knowledge basically on all the 64 cases. In latter phase, I used to write also. And then in latter phase, I have gone through the books of yours, sir. I have gone through your books also on ethics, sir. Because my way of preparation was, I was a little very clear that I should have lots of study material. And because new study material gives you a chance to read little more. Let us suppose that I have read one author, then second author books like your book has come to my hand. So I have an inquisitive idea that let us have that what is new in this. And good thing was that books and notes provided by your sir, that those are very brief, because it is not time consuming. Because some of the books which are available in the market, frankly, I'll tell you that I have purchased those books. I have purchased those books, but I have not read it.
Because of
Because,
bulky.
because of it was a voluminous, sir. Like it is traveling in 2,000 pages. So it becomes very difficult, and even you cannot you will just miss the basic. So my conquest was that I must focus on the basic, and basic means again in 4-5 segments. So for every case law, I have attempted in the same way. In latter phase, like your channels, YouTube, you have again descriptions and lot of narrative explanation of all these case law. So I have segregated from YouTube or other resources, and I have compiled at one place. So while going for morning walk, evening walk, etc. So what happened? I used to hear one by one. And again, while traveling either in car or traveling in the metro, I used to think that Somani साहब ने जो लिखा है या बताया है, or any descriptions, any description I have read, whether I have understood or not, or whether I have a gross idea of that leading cases or not. So in these way, but again I have a caution here. I was expecting to have a lead in this subject. I never I was never expecting that I shall take a lead in third paper, but I was expecting, because this was my core subject. Even as a judicial officer, most of the cases I have read it before. Many cases I have read it much before.
At the
But
time of practice, at the time of your JCP.
Ji sir. So I have referred those documents in past, but to my folly and to my misunderstanding, what mistake I have committed in the examination, that I could borrow the text and language from SCR notes, which have been provided to us, with an intention that I do not deviate. But probably that could not impress the examiner, sir. And I haven't got very good marks as I could have got. Like Lalita Kumari was asked, and other few other like P. Ramachandra Rao was asked.
Yes.
So
They can ask any question on any case laws.
So
And now,
so my token of suggestion is that we should have a gross idea of most of the cases, and we should not think either important or non-important. You should not bother about. We should have gross idea of all the cases. In case we have gross idea, because the last time the question was very tricky. They have given a synopsis. They have not given the case law. First question was that locate that from which judgment this has been taken from. So in case somebody has not studied the leading cases on that subject, probably he will not be able to locate that from which judgment it appears. And then also tricky question was that 20 marks. 20 marks questions were yes or no, sir. And that was covering almost 40 judgments, sir.
oh,
That was covering half marks. Almost they have covered 40 judgments. So now the ideal situation is that almost 60 judgments have been covered in a single question paper. So we cannot declare some leading cases as an important, and some others are not important. Now, new addition to this, those are very good case law, and for every advocate, whether he is an AOR, non-AOR, senior, or anything, they must have a gross understanding of those. Again, I have a caution here that due to some controversy about AORship and non-AORship, and even the qualities of AOR, because yes, it is surprising that AOR basically they should not be all alone bookworm, because they have an exposure of 8 to 10 years, even 20, 30, 40 years of practice. So they are supposed to be a complete package for that, and they should not take an excuse like some AOR filing a SLP and indicating repeatedly that there was a consent, lordship, there was a consent, and it was admittedly that victim was minor. So definitely this basic concept, like recently I was dealing with one transfer petition. And in that transfer petition, somebody is writing that transfer this matter from Maharashtra Session Judge to Judicial Magistrate Ghaziabad. To Judicial Magistrate Ghaziabad, sir. And even in that transfer petition, it is mentioned that some of the FIR is being tried by civil judge. So my conquest is that this time examiner might be little tricky on that issue, and maybe that lots of question might come from a practical situation. So a procedural law, and even I personally feel then Supreme Court may introduce some of the procedural law or one separate paper for the separate combination of all law like evidence, CPC, CRPC. They might have come out with some objective question of 100 marks in future, so
Yes.
that the examiner or any advocate on record, they do not say or it doesn't appear that either he is weak in literature, language, or he doesn't have a basic understanding of law and coming and pleading the matter which is beyond the expectation from a normal advocate, sir. So on these count, all the experience has to be little precautious on that, sir.
Very good. Very nicely explained. And
Sir.
I would like to tell the audience, uh, I think 2 or 3 years back, I have taken one webinar on Supreme Court procedure. And that webinar is on my YouTube channel, Jayprakash Somani
Sir,
YouTube channel. So 2 hours
sir.
webinar is there, but that is not for AOR examination. That is for the general practice of Supreme Court.
Sir,
So,
sir.
and recently I have completed BNS, BNSS, Evidence Act, BSA, then Constitution and CPC. All these law I have completed for rememorization process of all sections. So all these
Yes, sir.
lawyer will get on my YouTube channel, and I'm myself is using that my video and audio while I'm going
Sir,
to walk for a morning walk or at the time of exercise. I'm
sir,
hearing
sir,
that
sir,
again
sir,
and
sir,
again. So
sir.
at least a leading lawyer, leading to become a leading lawyer, and after become a leading lawyer, once in a 6 months, we should repeat all these books, at least their section and content, so that we can get the mastery on that. Number one.
Sir.
Number two, I want to add the one more point. Even though you are not giving AOR examination, even though you have passed that AOR examination, even though every year all four question papers, every lawyer who is practicing in Supreme Court should read that question paper of AOR examination, because things are changing. If, for example, somebody had given that examination before 10 years, that he cleared that examination before 10 years. But before 10 years, the question paper pattern, because his knowledge required is very different. But nowadays, knowledge required is very different. So
Sir,
for
sir.
current updation of that knowledge while practicing Supreme Court, this is very essential. So even though I am not giving that examination of AOR, I had not given that examination of AOR, even though I am reading that question papers after completing that examination, I am taking that question paper from any my student who is using
Yeah.
that my books. So I'm taking that question paper from him, and I'm reading that question paper. What exactly examiner's view is in that, like that. So I would like
Sir,
to
sir.
summarize the points of the Dr. Mithilesh. I would like to summarize that point. And last, I would ask you something. Just hold on. So main summary is that of Dr. Mithilesh's speech. Every day, 4 hours, we should at least work hard on this examination preparation of this AOR examination. Then daily we should write something. So for writing practice should be there. Our handwriting should be eligible. Our and time management at the time of our paper. That time management is very important. Don't give so much time for reading. Give the reasonable for time reading. Write the paper. Write the proper paper. Leave the gaps in proper. Then write the citation also whenever is essential. Write the case laws citation, write the sections also whenever is there. That will get the impression on the examiner, and that it is very easy to clear this examination in first attempt also. But Supreme Court is very great. They have given the exam chance, five chances for giving this examination. So obviously, who wish to clear this examination, they will obviously clear that examination. Last, Dr. Mithilesh, what
Sure, sure.
three things you would like to tell the audience about the preparation of the AOR examination? Three things that may be
Um,
repeated, but
no, no, sir, sir.
hmm,
But channelize your time,
hmm,
devote proportionate time to all the subjects. Do not concern, do not take anything as a scoring and non-scoring. Even do not mind for result. Kindly concentrate on the philosophy of Gita, that do the karma. Let
correct. Karmanyevadikaraste
sir,
mapaleshita
sir,
rajan.
let the result be given to you by God. And even if you do not succeed, still you are equipped. You are a better human being, better learned lawyer. And with that, I think you can
Yes,
achieve the task.
yes, all lawyer of India, if prepare 86 leading case laws, na, they will be an expert lawyer in their field, even though they are not
Sir, sir,
practicing in Supreme Court. So such
sir,
type
sir,
of
sir.
syllabus is this. AOR examination is not only for practicing in Supreme Court, but that examination pattern, examination input, everything is related to the increase and enrichment of your acumen of legal acumen, like
Sir,
that.
sir.
So, audience, sorry, little bit later I finish because
No,
I
no, no,
think
no,
in
no
one
issue, sir.
hour we should finish that, but a little bit more time is there. But
Sir, sir.
we will take separate session of Dr. Mithilesh on professional ethics paper. So, separate 1 hour session we will take in near future in within a 1 month we will take that session, and we will take the 4 different session also who have cleared this examination with good marks. In suppose, for example, I think one paper, some got the out of 100 marks in drafting
Sir,
paper
sir, sir,
or
sir,
something.
sir, sir.
So we will take their guidance also. And for example, for the examinees of this AOR examination, and we'll put all this video on YouTube channel. So forever you will get that. And there is one play group of AOR examination on YouTube channel. So you will find my last year also some interviews and like that. So you can get that video again and again. And I think you clear that examination. And when you clear that examination, don't forget to mail us, tell us we clear that examination. And and you meet you. We invite you to meet to Supreme Court. Dr. Mithilesh will be there. I will be there. Okay, you join us for lunch also. Or I'm speaking to all audience. Okay, and as a guest speaker, we will pass on one memento to you in physical form in the Supreme Court. And we want to give you one lunch also on behalf of Nani Palkiwala National Law Club. And this is a Nani Palkiwala National Law Club's moment. And if you are the member, I'm telling this to audience, if you are the member of Nani Palkiwala National Law Club, you will get such type of different program. And to become a Nani Palkiwala National Law Club member, no entry fee is required, no annual fee is required. Only you contact to my PA. PA's number will be in this description of this video. You mail. I will spell that number: 93221 93221 88701. 93221 88701. You just messaged to my PA. Just I want to become the Nani Palkiwala National Law Club member. So Nani Palkiwala National Law Club NP-NLC official 1 and NP-NLC official 2. These two are official groups there. That is admin control group. That is only official group. If you join that group, you are by default the member of Nani Palkiwala National Law Club. And we have 16 different group of Nani Palkiwala National Group. That is for your discussion purpose. So one is criminal law group, one is corporate law group, one is army matters, one is service matter, one is women's related matters, one is related to politics, one is related to trips, every. So all links we are not adding to anyone. Don't tell us, don't tell me, don't tell Manoj to add us in Nani Palkiwala group. We are not adding to anybody to any group. We will send you the link. My PA will send you the link. and which group you required, you join that. But official 1 or official 2 group, you join that group, then you will become the official member of Nani Palkiwala National Club. Nani Palkiwala was my guru, and with their inspiration and especially his devotion to maintain our democracy through the doctrine of basic structure from Keshwananda Bharati case. And on 16th January, we celebrated Nani Palkiwala's birth anniversary, birthday. Birthday we celebrated on 16th January in that Krishna Memon Hall opposite Sea Gate of Supreme Court. And before that, I have taken 8 to 9 different webinars on Nani Palkiwala's orientation, their speech, how he spoke in, how he argued in Keshwananda Bharati case, Minerva Mill case, so and so. So after that 8 days continues my efforts of taking like a fast, and then we celebrate that program. All the program, everything is available on YouTube channel. So kindly, just my request to audience, don't call me personally for any academic guidance of AOR examination like that, because we are practicing lawyer in Supreme Court. We don't have time to give personal guidance. But if anybody from Supreme Court want any practical difficulty, if he is facing so understanding of any high court case, understanding of case, and practically at the time of practice in Supreme Court, if you require any help, you can call me definitely, because I am there to help you practically, but not academically. So academic people are different. I am not academic person, but may Dr. Mithilesh can guide you academically also. And there are Raju Sinha also. He is my one friend, Raju Sinha. He's also running very good AOR foundation, and he is giving regular time for AOR examination preparation also. So Raju Sinha, and there are I think Bihari. One Bihari is also my friend. So he is also very good. So many are people trying. So just prepare well, focus on your examination, focus on your practice. Even though you are not getting chance to clear this examination in first attempt, second attempt, give second attempt. Every time you will read it again and again, more and more, and you will become expert in this. Okay. Thank you. Thank you very much. Jai Hind. Namaskar. Vande Mataram.
Thank you so much, sir. Good night,
Thank
sir.
you. Thank you.